Ethan Crumbley, the 15-year-old responsible for the Oxford High School massacre, had his first felony court date today called an arraignment. We're going to break down exactly what happened. A short proceeding, only took about 4.5 minutes, but it goes quickly. There's a lot happening, and so I want to make sure we can break it down piece by piece. Now remember, this is the court that he's in now, but we see new faces. Judge and the bailiff have changed because we were going from a lower level circuit court up and now what feels like a superior court. Now, I don't know what the terminology is in this state, but here we have lower level courts and higher level courts. Same thing exists there. They were in a lower level court. Now they're having to redo sort of an arraignment process because they waived the preliminary hearing at a lower level court. Here they are now. So let's take a look at who some of these key players are. We're going to notice down in the bottom right, we've got the judge. Judge is going to be announcing himself. Actually, the bailiff up here in the top left is going to be announcing the judge. The judge is then going to be asking for what are called appearances. And every single person on this screen is going to announce themselves. And so let's identify who they are. We've got down here in the middle in the red is going to be the prosecutor. That's Karen McDonald. We've got Mark Keast. We've talked already about him right above the judge. Mark Keast is the prosecutor that we heard a lot about in the parents' motion to modify their release conditions. Remember that James and Jennifer Crumbley had asked the court to let them out of custody or reduce their bond from $500,000 to $100,000. Judge denied that, of course. And we heard argument from both Mr. Keast here and from Miss McDonald here. And so they're back, of course, to representing the government in both cases. They're joined here today on this court proceeding by Miss Collins here, who is another assistant prosecutor. We've got defense attorneys here in the middle. Paulette Michelle L. is going to be representing Crumbley. And then we've got Amy Hoff, who's over here, also going to be representing Crumbley. And then we have a guardian ad litem. This is basically an appointed attorney who's supposed to be looking out for Ethan Crumbley's best interests. And so that person, her name is Deborah H. McKelvey. And so that's everybody who's a part of this event today, this arraignment. Let's listen to how the appearances go.
The Oakland County Circuit Court is now in session with the Honorable Kwame Rowe presiding.
Thank you. Good afternoon, everyone. Appearances for the record. When you give your appearance, please indicate whether or not you consent to proceed via Zoom this afternoon.
Karen McDonald on behalf of the people, and I consent to the Zoom hearing.
Thank you. Mark Keast on behalf of the people. We consent.
Good afternoon, Your Honor. Assistant Prosecutor Kelly Collins, appearing on behalf of the people, and I too consent to Zoom.
Good afternoon, Your Honor. Paulette Michelle Lawson on behalf of Mr. Crumbley. We are consenting to proceeding by Zoom.
Good afternoon, Your Honor. Amy Hopp on behalf of Ethan Crumbley. I consent to Zoom as well.
Good afternoon, Your Honor. Deborah H. McKelvey, court-appointed guardian ad litem for Ethan Crumbley, and I have no objections to proceeding with this matter on Zoom this afternoon.
So those are the appearances of everybody who's going to be working on the case. We now know it is in a new court. This is a felony proceeding, and so the judge is going to be making sure that there's not any problems with him specifically, Judge Brown, representing or let's say presiding over this case, because it turns out he used to be a prosecutor, and so wants to make sure there's no conflicts here. Sounds like they had a conversation about this before the court proceeding took place on the record. Here's what they determined.
Good afternoon to all counsel. Good afternoon, Mr. Crumbley. Mr. Crumbley, can you hear me, sir?
Yes, sir.
You understand that you have a right to be present in court today. Are you okay with proceeding via Zoom just for the purposes of this arraignment?
Yes.
Thank you. Prior to calling this case, the court did have a brief breakout room with the attorneys. I did discuss the issue of any potential conflict. As all attorneys on the call are aware, I was a former assistant prosecuting attorney at the Oakland County Prosecutor's Office. Upon talking to counsel, I do not believe there's going to be any conflict with me presiding over this case. Is that correct, Ms. Lofton?
That is correct.
Okay. Any objection from any attorney on the case of me presiding over it?
Not from the people, Judge.
No, Your Honor.
Thank you.
Okay, so no conflict of interest. So we don't know if there was, some sort of working relationship between the judge, Judge Brown, and either one of these prosecutors in any way, shape, or form, whether he was a subordinate or a supervisor or, an equal. He was an assistant prosecutor over, sounds like, at the same office, but they're asking the defense attorney, do you have any problems with that? Is that an issue for you? Do you think that I'm going to be biased or show them any favor? She says no, And then Ethan Crumbley's guardian ad litem says no. So no problem. So this will continue forward. Of course, we also heard from Ethan Crumbley. He is aware of what's happening and ready to proceed. So the judge then decides he's going to end up keeping the case since there is no conflict.
And with that being said, the court is comfortable with proceeding in this matter, and I don't believe there to be conflict in this case.
Which is good news. So he'll keep the case. He's happy about that. And now we actually get into the arraignment. The arraignment is going to be very, very sort of brief. Listen in. Let's listen to it, and then I'll explain what happened.
Today's date and time set for an arraignment. Ms. Lofton?
Yes, Your Honor. I would waive the formal reading, stand my client mute, ask that a not guilty plea be entered.
Thank you. The court will accept jurisdiction, enter a not guilty plea on behalf of your client. It's my understanding that according to the
All right, that's basically it, right? That's kind of the arraignment. I mean, he's going to go in and set some dates here in a minute, but that's the real nuts and bolts of what's happening here. What are we trying to accomplish with an arraignment? We got to enter a plea. And she just did it. It happened real quickly. She said a couple things. She said waiving a reading. What does that mean? It means that she doesn't need the court to advise Ethan Crumbley or the defense counsel about what he's been charged with. We know what the charges are. We've seen it. It's been in the news. So we don't need the judge to formally announce and say the charges out loud. Ethan Crumbley is charged with count 1. Don't need to do that. Judge says, we're just going to go ahead and waive that. Perfect. I'm sorry, the defense attorney says, we're going to waive that. Judge says, perfect. Skips right over it. She's basically saying, I'm going to be speaking for my client. You're not going to have to hear from him. No problem. We've already got a record of a notice of appearance, so the judge is allowed to, the defense attorney is allowed to do that. And then saying, Judge, we're going to enter a plea of not guilty. And then that's where, that's okay. Judge says, perfect. I've got jurisdiction. I'm going to accept that not guilty plea. If he pleads guilty, well, the case is over, right? He takes a guilty plea, goes and has a pre-sentence report and gets sentenced. But in order to set the next court date, we got to start somewhere. This is where we enter the plea of not guilty. The judge is going to come back and set some additional dates. Here's what that sounds like. And since he's a juvenile, we have a little additional question about what do we do with him? Where do we put him? The judge wants briefs on that.
That according to the Juvenile Justice and Delinquency Prevention Act, that a hearing must be held before January 21st of 2022 regarding the placement of the defendant. However, because of the pandemic, we cannot effectuate an in-person hearing, which I believe it would be appropriate in this case because of the high number of COVID cases, the positivity rate in Oakland County. Because the number of COVID cases are so high at this time, the court is finding good cause to extend those 30 days because we cannot effectuate an in-person hearing at this time due to the positivity rates. It's my understanding that defense is requesting in person, and I believe that is absolutely appropriate in this matter. And so what I am going to require the attorneys to do is to submit briefs on this issue. Briefs are to be submitted on the issue of placement on or before January 19th, 2022 by 2 p.m. And we will also have a status conference on January 19th, 2022 at 2 p.m. And that status conference is only with the attorneys. And the purpose of that status conference is just to set a new date for the hearing under the Juvenile Justice and Delinquency Prevention Act. And I will note, because of the high number of victims in this case, that this recording will be posted for 24 hours after today's date.
So I'm not real sure if there's actually going to be much argument over placement. I don't know if the defense is going to want him placed in one location or the prosecution is going to contest that, if they're going to fight too much over these things, but we'll see. And they may just come to a stipulated agreement and just say, look, Judge, we had a conversation about it. We think this is the appropriate place for Ethan Crumbley to be housed pending trial. And it may be very simple. They come back, submit that conclusion to the judge. The judge makes the final order about where to keep him. But the judge also extended the time in which he has to make that decision. The law said he had to decide by a certain time, but gave him extension allowances when there's exigent circumstances, where there's emergency circumstances. And that's exactly what he is saying is happening here. COVID is a problem. And so that's going to give him some additional tools, some additional leeway on extending these dates out, and he has done that. So now we have two final clips. This is where he is reappointing the defense attorney, who sounds like it was appointed through a sort of a public contracting operation that they have. Here's how that sounds.
The last issue I believe that we need to address is the issue of appointing LGAL. I did have an opportunity to speak to counsel. This court is reappointing Ms. Deborah McKelvey as LGAL for Mr. Crumbley throughout this matter. Is there anything else from either party?
So that's actually this woman here. So a guardian ad litem. This is somebody who's supposed to be looking out for Ethan Crumbley's best interest, sort of as a juvenile, somebody who's under the age of 18. The defense attorney has a sort of a different job, slightly, of course. They're looking out for Ethan Crumbley's interest against the criminal prosecution, but somebody else is looking to, sort of representing his interest as a juvenile because his parents are not there, right? So sort of fulfilling the role of kind of a parent, which would be different than a lawyer. So it's a complicated situation because mom and dad are not there to talk to the defense attorney or anybody else really involved in the case. So they've appointed her. They're going to reappoint her. And then this is it. That's basically the end of the proceeding. We have the prosecutor, Mr. Keast, wants to make sure that the defense got a copy of the general information, which is just, a list of the charges to make sure that she got the document, essentially. Here's how that sounds.
Is there anything else from either party?
Yes, Judge, thank you. I just wanted to make sure that Ms. Lofton did acknowledge receipt of the general information.
Yes, I have the general information.
Thank you.
Thank you. Anything else from either party?
Now watch as
Not
all
from the people.
Zooms-
Thank you, Judge.
Nothing from defense, Your Honor.
Watch as all
Okay,
the
Your
Zooms
Honor,
leave.
thank you.
Who's left? It's
Thank you
only
very
the
much.
bailiff.
I will see you all on January 19th at 2 p.m. And again, that's only the attorneys. Mr. Crumbley, you will not be present for that hearing. We're just setting that so we can set a new date. If there's nothing else, everyone is all set. Everyone have a great day.
Thank you very much, Your Honor.
Thank you.
Bye.
Thank you.
Everybody bails. And there's the bailiff and Ethan. All right. And so we know that they're coming back. We've got a little bit of a brief that is due. Not sure if it's going to be anything substantive or consequential other than where Ethan is going to be living for the foreseeable future. But that is taking place on the 19th. We'll be back to cover it. We've also been following James and Jennifer Crumbley. Their video, if you want to watch the latest on them, is up here. They tried to get out of custody. Judge said no. So check that video out. Otherwise, I hope you come on back here and join us as we continue to follow Ethan Crumbley's case. There's a lot of very interesting things going on with Ethan. Talked a lot about him at his prior court date, which that video is available up here if you want to check that one out. Ethan Crumbley, we learned some new things about his journal and about what's going on with him. So make sure you're up to speed on this case because there's going to be a lot more that comes out as we learn more about how the parents let this whole thing get to the point that it did. And I hope that you join us as we continue to follow it along. I look forward to seeing you on the next one, my friends.